Friends, welcome to my channel. Today I'm going to deal with Doctrine of Part Performance, which is provided under Section 53A of Transfer of Property Act 1882. So let's begin. So friends, I'm going to start with the clear provisions of Barrett. So this is the provisions of provided under Section 53A of Transfer of Property Act 1882. So Doctrine of Part Performance, where any person contracts to transfer for consideration, any person, okay, there must be some kind of person, for example Mr. A, and he contracts to transfer something for, of course, consideration. It may be consideration in terms of money, okay, any immovable property, and the kind of property here is, of course, of immovable property, the kind of property which cannot move, okay, it is immovable property, not goods, by writing signed by him. And this is also by writing, that means it is formal transfer, and he must sign at the foot of it, so signed by him or on his behalf. If he do not sign, then some other person have to sign on his behalf, from which the term necessary to constitute the transfer can be ascertained with reasonable certainty. So there's Mr. A. He is making a contract. This is a contract of transfer, and transfer is for consideration, and the transfer is of a kind of property. The property is mainly of immovable property, and he makes the transfer by writing plus sign, okay. And if the sign may be his own sign, he may make sign by him or in his behalf, means some other person may sign in his behalf, which the term necessary to constitute the transfer can be ascertained with reasonable certainty. So in this paper of contract, so this is the paper of contract, okay. So number 1, number 2, number 3, these are called certain terms, and these terms are very necessary to include in this contract, which are necessary to constitute the transfer, so that the transfer can be ascertained with reasonable certainty. Very clear and precise terms are set in these contracts, okay. And then in the next step, the transferee. The transferee means the person who takes the property, means who purchases or buys the property, right? In part performance of the contract, means performance of the contract, we can say taken possession of the property. So the house, for example, it is a house, immovable property, has gone from the hands of transferor to the transferee. It's called possession, taken possession of the property. So Mr. Transferee, that is Mr. B, is in possession of the immovable property, okay. So taken possession of the property or any part thereof. It may be the whole of the property or it may be the any part thereof, but taken possession is essential. Or the transferee already being already in possession, continues in possession in part performance of the contract, and has done some act in furtherance of the contract, and he has done also some act in furtherance of the contract. So here from these lines we find that Mr. Transferee, that is, of course, so we can say Mr. B is very willing to perform his part of contract, or actually partially perform his part of contract, or at least he is willing to do so. So from this sentence we find that the transferee has performed, either he has already performed, or at least he is willing to perform his part of the contract. That's great. But what about transferor? Means what about Mr. A, the transferor? Then, notwithstanding that the contract though required to be registered, of course we know if the value of the property exceeds rupees 100, then it must be registered under Indian Registration Act 1908. But the property, of course, is required to be registered, yet it has not been registered. It has not been registered, but the contract is there, written contract is there, it is signed by the transferor or some other person in his behalf. So and also the terms are also properly set out in this contract, but it is not registered, no registration. So has not been registered, or where there is an instrument of transfer. But the instrument of transfer, for example, I am referring to this contract, the instrument of transfer, that a transfer has not been completed in the manner prescribed therefore by the law for the time being in force. But one thing is left here. There is one thing which is not yet done, that is not completed in the manner prescribed by the law. But the transferee is willing to perform his part of the contract, but it is incomplete kind of transfer. 50% has been completed, while 50% has left, and this 50% is registration of the document. Then the transferor or any person claiming under him shall be debarred from enforcing against the transferee the person claiming and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possessions, other than a right expressly provided by the terms of the contract. So what does it mean? Provided that nothing in this section shall affect the right of transferee for considerations who has no notice of the contract or of the part performance thereof. So I'm going to explain it with an illustration. So there is an illustration. This illustration was held in the case Nathulal versus Phulchand. Nathu. So Nath Ulal versus Phulchand. Okay. Mr. A sold his ginning factory with land. Factory plus land. With that's a plus factory plus land to Mr. B. B gave part of purchase money. B didn't pay the whole of the money, but at least part of it. For example, 50% of the money, and got the possession of also. B sued A then thereafter A sued B for eviction for not paying balance of money. A has agreed had not opened khatta and attended property. As A is agreed had not opened khatta and attended property, held B could claim part performance to doctrine. And the doctrine of part performance is based on the doctrine of equity. Because of course B is willing to perform, B has already performed or willing to perform his part of the performance. So the document has not been registered. If A on the basis of non-registration wants to do something, wants to evict B from the property, as A want to transfer it to someone else, for example C, then it cannot be done on this basis, because there must be some kind of justice, and it is based on the principles of equity, and equity requires then one who wants to do just the one who seeks justice must do justice. So I'm going to explain again it properly. So let's see here. Doctrine of part performance, section 53A. A is of course amendment of Transfer of Property Act. The doctrine originated in England, and in the leading case, Medicine versus Ederson. You can refer this case in your exam because it's very important. The statute of frauds required that all contracts relating to land must be in writing. Of course, writing. This led to many difficulties. A orally agreed to sell B. For example, A orally agreed to sell his land to B, received the price and put B in position. A could reject B simply because the agreement was oral. So here, Mr. A is of course willing to perform his part, and he has already taken position. Either he performed the whole of the contract or part of the contract. So Mr. B, being very deceptive, wants to take benefit of non-registration, or wants to take benefit of non-compliance of the provisions of the law as regards to transfer of property. So in this case, the law will do justice in favor of Mr. A and not in favor of Mr. B, even though the procedure, the manner prescribed in law has not been complied with. Because equity demanded that the statute of frauds itself should not be an instrument of fraud. Statute of fraud was enacted for the purpose of preventing frauds. But because it is enacted for the purpose of preventing fraud, that's why oral transfer is not included, and the transfer must be written so that there will be no fraud. But It must not be, on the other hand, in the hands of some kind of deceptive transferor, a instrument of fraud, who can use the non-compliance of the provisions of statute of fraud and can do injustice to the bona fide transferor. This lead to the enunciation of the doctrine of part performance. So here we find the doctrine. Doctrine means the principle of part performance. That's really interesting. If due to the absence of written document, the agreement cannot be provided in court, it is enforceable in equity. It is not enforceable in law, of course. Because the agreement cannot be provided in court, it cannot be provided in court as an evidence. Law do not accept this kind of evidence, which because the agreement, for example, in case of Indian, in case of when in registration is required under Indian Registration Act 1908, then you have no evidence in your hand, even though you have performed your part. If you are a transferee, you have performed your part, but you have no evidence in your hand to produce before a court of law. Okay, so this is not the doctrine of law, but it's the doctrine of equity. It is enforceable in equity provided the party seeking the remedy has acted in part performance of the agreement. The only condition here is required that the person must perform his part of agreement. The doctrine where a person contracts to transfer any immovable property by writing signed by him or his agent using systems necessary to constitute a transfer with reasonable certainty, and transferee has performed or at least willing to perform his part of the contract, then it is cured of the defects. It is cured. Cured means there is cure of the defects. Of course, the defect is there, defect of non-registration and non-compliance with the prescribed manner of execution according to law, which we have already read in the beginning of this video. Further, the transferee is barred from enforcing against the transferee any right in respect of the said property. So the transferor, for example, taking benefit of non-compliance of provisions of law or non-registration, cannot evict transferee who has already performed or at least willing to perform his part of performance. That's the same thing I'm saying again and again. So that's a very easy and simple concept. If you understand, it's not very tough. The section also has protection of bona fide transferee for valuable consideration if the transferee is bona fide, means with no malafide intention, and from valuable consideration who has acted without notice of contract or part performance. And also some other kinds of transferee, subsequent transferee maybe, who has also paid the money and who is bona fide, but who has no notice, who acted without notice of the contract or part performance, without notice of the previous transferee's part performance. So it protects the interest of subsequent transferee as well. Then comes the census. The transfer is for valuable consideration has gift or excluded. So gift is creditors transfer, means there is no consideration, no monetary value in no consideration in terms of money, so it is excluded. Writing, there must be a written agreement, hence oral agreement will not suffice, because in case of what we have to in case of statutes of fraud in England, so it's a different thing, where different thing between Indian law, oral agreement will not suffice. It must be in writing at least. And in practically most of the people makes contracts in writing and not orally. It rarely happens in India. The agreement should be signed by the transferor. Of course, the transferor sign is necessary, and if the transferor do not sign, then he is duly authorized agent, as we have already heard about power of attorney, like something like this, authorization. Then 4 applies to immovable property only, not movable, because if you see the Transfer of Property Act as a whole, then Transfer of Property Act mainly deals with transfer of immovable property, except in few other cases. And in case of transfer of movable property, then we already have Sales of Goods Act. Then comes 5. The terms of contract must be capable of being ascertained with reasonable certainty. So this is very important for the court of law or equity. Then there must be a contract, and the terms must be ascertainable with reasonable certainty. There must be terms of agreement. and it must be ascertainable with reasonable certainty. It must be ascertainable, means it must be written in a precise, clear, unambiguous language, and which can be easily ascertainable, and that is of course with reasonable certainty, region and certainty, it must be there. And then comes point 6, the transferee must be in possession of the immovable property, and the transferee must be in position, he must be in position, that's why he cannot be evicted. So and then 5, then 6, 7, the transferee must be ready and willing to perform his part. The transferee, Mr. Transferee, must be ready and willing to perform his part. He's wearing a sunglass. Then comes nature of the right. This right in respect of part performance is only a defense to the transferee. So it is a defense to the transferee. This is a shield and not a sword. Okay. So shield means what? It is a shield. Nature of the right. Nature means what kind of right it is actually. So this is a shield. Okay. So it is a kind of protection for whom? Mr. Transferee. It is a shield and not thereby a sword. So this is the sword. Sword is used to kill someone, and shield is used to protect himself, and sword is used to kill others. So it is a shield and not a sword. It does not create a title. It does not create any kind of title. The transferor is barred from asserting his title. But one thing is here, there is a logic we find, that it does not create any title. But on the other hand, the transferee is also barred from asserting his title as well. The transferee cannot maintain a suit on title because the deed is not registered. It is not registered. That's why he cannot maintain a suit in a court of law. That's why the whole concept is based on equity. There is limited scope according to the Supreme Court. There is limited scope according to the Supreme Court, as held in Ram Gopal versus Custodian. So this is the case. So we find here 4 to 5 cases, right? But not explained properly. Now, we have already read about this Nathu Lal versus Pulsant. I'm again going to read it. A sold his Guinea factory with land to B. B gave part of purchase money and got possession. A sued B for evictions for not paying balance of money. A agreed had not opened khatta and attended property. Okay. Held B will claim part performance. I have already explained this even in this video. Then comes another case in the technician's studio versus Leela. L has leased it in case of lease. Okay, lease her premises. L had leased her premises for 5 years. The term of the lease is 5 years to T, because L is leaser and T is tenant. So L sued T for eviction within 5 years. Within 5 years. Although the period is 5 years, but why L can sue T for within 5 years? Held T may invoice part performance doctrine. T may invoice. T has performed his part. So after the expiration of 5 years, probably L may sue T, but not before it, because it is a doctrine of part performance. Technician's studio versus Leela. So how many cases we have find? Let's revise it again. This is revision part. Number 1 case is here, Madison versus Ederson, and it relates to statute of frauds in England, originated in England. Okay, number 1. Number 2 case is Ram Gopal versus Custodian. Ram Gopal versus Custodian. Mr. Ram Gopal Ram Gopal. Ram plus Gopal versus Custodian. And this is the case. In this case, what was held? There is the limited scope according to the Supreme Court. Limited scope of application of this doctrine according to the SC, which was held in Ram Gopal versus Custodian. This is case number 2. Case number 3, Nathu Lal versus Pulsant. Nat is title. Nathu Lal. Thu and Lal. Nathu Lal versus Phul. Phul means in Hindi flower. Phul. And Chand. Chand means the moon. So it is moon. Full Chand. Nathuram versus Phulchan. This is we have already discussed the fact of this case. Then another case is Technician Studio versus Leela. Technician Studio. It's a very cool name, right? Technician Studio. There is a studio, Technician Studio versus Leela. Leela is a name of a woman. And what is the meaning of Leela? I don't know. But you can make your own. You can make your own mind map. It's up to your own imagination how you do it. So this note was really very short for final exam revision which I have made. So it is not very, I mean, it's brief, but yet it has good content, so it can be helpful for you. At least I have explained the concept itself. You can choose more cases. And thanks for watching. Please do not forget to subscribe to this channel if you like my videos, as well as please to comment so that I can understand whether I am able to present it properly or not. Thank you. Thanks for watching.